Hello. Good afternoon again. This is Dr. Olu Asekun here. Welcome to my podcast. Today is another Wednesday. Remember to call your friends. Remember to call your colleagues at work. Remember to call your family members. Here is another opportunity to obtain free and very useful information. Welcome to our live podcast every Wednesday, 12 p.m. Central Standard Time. So, today we are discussing a very, very important topic, which is how to force USCIS to adjudicate a petition or application. Can you please put the topic?
Okay. Yes, sir.
Maybe the color, you need to change the color. I can't read it. So today's topic is how to force immigration to adjudicate your petition. It's a very, very, very important topic because prior to COVID, since 2016, and during and post-COVID, cases and applications have received unprecedented delay, and lots of people whose applications or petitions should have been adjudicated. It is what you paid for. It is something you pay for, and you are entitled to adjudication. Now, adjudication does not mean approval. Adjudication also does not mean denial. It simply means adjudication. It simply means that they have to review your application or petition and take a decision. They cannot sit on it. So, how do you force them to do their job? There are ways that they can be prompted to do their work, and there are ways that they can be forced to do their work. One of the ways to prompt them to do their work is to do what we call service request. So it's like an inquiry. What is causing delay? Why is my application being delayed? It's like an inquiry. So if you do a service request, usually immigration will get back to you within 30 to 60 days. But oftentimes, they come back with generic response. Oh, your application is undergoing security review. Oh, your application is undergoing security clearance. Oh, we cannot determine how long this application is going to take. Oh, we are currently experiencing a backlog. We cannot tell you how soon the application will be adjudicated. Those kind of response, which sometimes can be annoying. So, what do? There are still other ways to prompt them. You can go through the ombudsman. You can request assistance through an ombudsman. However, if all attempts to get them to do their work fails, then what do? If you are eligible, it is not every case that is eligible for what I'm about to say. That is why it is very, very important to seek advice from an experienced immigration attorney. But one way to force them, this is not a question of now pleading or appealing or prompting, but to force them to do their job is by a process known as Mandamos. Mandamos. If you file a Mandamos action, Mandamos come from the word mandatory. So the court will mandate them to do their job. Now, if for any reason they are not going to do it, they will have to explain to the court why they are unable to do it. And I can tell you, Mandamos is almost certain to force them to do their work. I don't use the word force lightly. I don't use it lightly. And I mean it when I use it. That is the only way you can force them to do their job. Again, you are not forcing them to approve. You are not forcing them to deny. All you are doing is forcing them to do their job that you paid for, because all these applications are not free. There are some applications or petitions where we pay over $20,000 in application fees. There are some applications where we pay about $17,500 in fees to immigration. There are applications where we pay $3,000. You are entitled legally to the benefit of your action. I have actually represented foreigners to file Mandamos action against immigration. No U.S. citizen was involved. No U.S. business was involved. In fact, these were self-petitions under EB-5, investors. And immigration delayed it unreasonably, and we filed Mandamos action. So the point I'm making here is that you don't have to be a U.S. citizen to file Mandamos action against USCIS if your case has been unreasonably delayed. As I stated at the beginning, these services are not free. They are paid for. If immigration were to be a private business and you pay for a service and they don't deliver that service, what will you do? You can't fold your arms. So the same way, although immigration is a federal agency, but they still have a responsibility, a mandatory responsibility to adjudicate petitions or applications that are paid for. So if after trying every other thing and immigration refuse or continue to delay adjudicating your petition, you can file a Mandamos action. However, there are some basic requirements before you can file a Mandamos action. This is why it is important that you seek advice from an experienced immigration attorney before you proceed. Number one, before you file a Mandamos action, you must exhaust all administrative procedure. Of course, that includes calling USCIS to find out about the status of your case, submitting service request to find out why your case is being delayed. You take steps and document all these steps. So once you take steps and you satisfy the requirement from the court, you have to show that, okay, I've taken all these steps. I've called them. I've submitted service request. All they respond with is the generic response. Your case is undergoing background check. Your case is going through security check. Your case is being delayed. We apologize for the delay. We cannot tell you when your case is going to be adjudicated. We have a lot of all those generic responses. That is not tenable in the court. If you pay for your application, you have a right for the application to be adjudicated within a reasonable time. The second requirement before you file a mandamus, you have to confirm that the published processing time has passed. Now, for every application or petition, immigration is required by law to provide public processing time for each application. In other words, when you submit an application or a petition, immigration will notify you that, well, for this type of application or for this type of petition, it takes 12 months to process, or it takes 18 months to process, or it takes 24 months to process, or it takes 3 months to process. So, before you can file a mandamus, if the processing time states 24 months, you cannot file mandamus before 24 months because they have given you advance notice that this application is going to take this long. So you cannot succeed if you file a mandamus. But if they publish that the type of application you file will take 18 months to process, and this application has been pending for more than 36 months, that is unreasonable. You can file a mandamus in such a situation. But again, it is better, it is advisable to consult with an experienced immigration attorney who will evaluate your situation, your peculiar case, and make a determination whether the route of mandamus is good for you or not. One thing I will tell you is that he who lives in a glass house does not throw stone. So before you go the mandamus route, ensure that you put your house in order. Otherwise, if they have reasons to deny your application, mandamus is not going to make them approve it. Mandamus simply means they have to do their job. They have to adjudicate the case. They have to take a decision. So if they have reasons to deny it, they will go ahead and deny it. And of course, if they don't have a reason to deny it, they cannot deny it. I think at this stage, I'll be expecting questions. I've not seen any question. Have they started coming in? Oh, yeah. Start sending in your questions. But in the meantime, I want to explain that filing mandamus does not mean that immigration is going to take a step against you for doing so. That will be against the law. I have been filing mandamus for almost 20 years. I am yet to see one single case where immigration decided to retaliate or do something because you filed mandamus. No, they cannot do that. In fact, if they attempt to do that, or if that is done, that will actually be another cause of action for liability. They will be liable. So the law does not allow that. But it simply means you paid for these services, you are entitled to the service that you pay for. That is what mandamus simply means. Okay, I think I have some questions here. I am in removal proceedings. I have a marriage-based I-130 and 485. Can I file mandamus? Yeah, the fact that you are in removal proceedings has nothing to do with mandamus. The issue here is mandamus is saying that your case has been unreasonably delayed by USCIS, and you want the court to force them to do their job. After all, you paid for these services. That is what mandamus is all about. Actually, I have filed mandamus against immigration for clients who are in removal proceedings, where I-130 petition was unreasonably delayed, and the respondent, the client, was becoming at risk, the immigration judge was threatening that he was no longer going to wait, that the court cannot wait forever for the I-130 to be adjudicated. So I filed Mandamos against USCIS. And of course, as expected, within 60 days, the application was approved. So, yes, the fact that you are in removal proceedings does not prevent you from filing Mandamos if your case qualifies for Mandamos. The next question: can the judge what they have a responsibility to do is to call immigration to order. Why has this case not been adjudicated? That is all they need to do. That is all what Mandamos is all about. And that is why it is very effective because, like I said, the court. The next question: what happens if the government files a motion to dismiss Mandamos? They cannot file a motion to dismiss Mandamos because, like I said, if you meet the requirement of Mandamos, the only thing they can do is to come back and present a reason why their case, why they are delaying the adjudication of the case. Now, let me say this. There are different types of cases. Most of the time, when you are forcing immigration to do their job, you also have to look at the type of application. For example, I have filed a Mandamos case some years back in Houston, at the federal court in Houston, regarding citizenship case. So the government in that case, that was during President Trump regime, the government in that case decided to file a response, filing a motion with the court explaining that we cannot force them to adjudicate the citizenship application because they have to do a lot of background check, they have to do this, they have to do that. They filed that motion for married children. Only U.S. citizens can do that. A permanent resident cannot petition for siblings. Only U.S. citizens can do that. A permanent resident cannot vote in an election. Only U.S. citizens can do that. A permanent resident cannot obtain American passport. Only U.S. citizens can do. There are unlimited list of what a U.S. citizen can do that a permanent resident cannot do. So, having lived in this country for years, having met all the requirements of citizenship, including submitting an application for citizenship and paying for the service, immigration cannot have unrestricted authority not to adjudicate the petition. Of course, at the end of the day, the court agreed with me. That case was a precedent case. I mean, precedent meaning that there has never been that kind of case before. So it became a precedent. Because the law states that when it comes to citizenship, after interview, immigration have 4 months, 120 days, to take a decision after interview. But in the case of this Mandamos case, it was even before interview. So that was immigration's argument that, look, we have not even interviewed this person. We are still conducting background check. We still have the right to do this. We have to. I said, no, you don't. Your right is not unrestricted. You cannot place a hold on somebody's life just because you are the government. No. This is still a country of law. The rule of law is what governs here in this country. And at the end of the day, the court agreed with me or application that you cannot file Mandamos for if you meet the requirement of Mandamos. requirement meaning that you must have exhausted all administrative processes, including calling them to inquire about your case, submitting service requests, maybe even try ombudsman, whatever you need to do to find out what is keeping this case, what is delaying it, when are you going to adjudicate it. You keep calling. So all the responses you get, you document everything. So once you exhaust that, then go back and check the processing time. If you are still within the processing time, you cannot file Mandamos. You cannot file Mandamos. But if you are outside the processing time, you are good to go. But again, remember to consult with an experienced immigration attorney, those who know what they are doing, because litigation is not easy, it's complicated. The next question. Does filing an inquiry to the Congressional office help to force immigration to provide a decision? No. I mean, the Congressional office is not different from when a lawyer calls immigration, what is the status of this case? They can only make an inquiry on behalf of a client or constituents. They cannot force anybody to do anything. They don't have any such power. They don't have any such power. Not even the president can force them to. I mean, nobody has such power. You cannot force them. The issue is there are rules and regulations in this country. There are adjudication rules. There are processing times. There are guidelines to follow. So it's not something that somebody is just sitting in his office or our office and just taking decisions. No, there are rules to follow. So Congressional liaison, sometimes they help, and sometimes they come back with the same generic response that we get as lawyers. Oh, this case is currently pending. We apologize for the delay. We are still waiting for the background check or security check. Oh, those generic responses. It's the same thing most of the time that Congressional offices get as well. So they are not in a position to force anybody to do anything. The only one that can force them to do their job is the law court by filing Mandamus. The next question. Could filing a Mandamus create an even further delay for the immigration case? No. Then it means you don't understand Mandamus if you are talking of further delays. Because as soon as you file a Mandamus, once you file a Mandamus action, you have to ensure it is mandatory. You must serve the Attorney General of the United States. Remember, immigration is an agency of the federal government. So most immigration officers, they are not lawyers. They don't know anything about law. So when you sue immigration, you are suing an agency of the United States. So under the law, you must serve 1, the Attorney General of the United States. 2, you must serve the U.S. Attorney representing the United States in the state where you file your action. So at the end of the day, once you have proof of service of these two, the Attorney General and the U.S. Attorney's Office, once you serve them, you file proof of service in court. So from the day that they are served, they have 60 days to respond. So technically, you are not even dealing with USCIS themselves. You are not dealing with immigration themselves. You are dealing with the federal government. It is the Attorney General or the U.S. Attorney's Office that will file a response to the case. So they are the one that will be dealing with USCIS, because now USCIS is now their own client. The way the client, we are the lawyer to the applicant or the client who is filing Mandamus. So USCIS becomes the client to the Attorney General, to the United States Attorney General, or to the U.S. Attorney's Office, the U.S. Attorney that is representing the United States government in the state or the city where the where the Mandamos is filed. For example, we are in Dallas now. So if we file a Mandamos action in the Federal District Court in Dallas or Fort Worth, because those are the two district courts in the DFW metropolis. So if we file it at the district court in Dallas, we will have to serve the Attorney General of the United States in Washington, D.C. In addition, we will have to serve the U.S. Attorney representing the United States in Dallas. So once we serve those two, from the date of service, they have 60 days to respond to the Mandamos action. The next question. Can I submit a second service request if the first service request is taking a long time? Oh yes, you can submit a service request as many times as possible. In fact, if you are going to go for Mandamos, it is advisable that you have multiple service requests so that you will be able to prove that you have exhausted all administrative remedies that you know. And like I said, as far as I know, at least, and I've been doing this job now for decades, as far as I know, immigration does not have any mechanism. There is no prerequisite for anybody to comply with in terms of administrative remedy. They didn't set up any mechanism for you to complain other than service request. So the only thing they have is service request. So call them, let them send you the generic response. Do a service request online, get a generic response, email, document all these things, try it multiple times, check the processing time. Once the processing time is over and unreasonably over, it's not as if the service request will say 12, and the processing time will say 12 months, then on the 13th month you file Mandamos. No. That may not be unreasonable delay. But where the service request where the processing time says processing time 12 months, and your case has been pending for 24 months, that is unreasonable delay. So if you exhaust other administrative remedies by calling, by doing service requests, you can go ahead and file a Mandamos action. And let me say this. One of the reasons why Mandamos is extremely effective is the fact that once you file Mandamos, you are not dealing with immigration. You are now dealing with the Office of the Attorney General of the United States or the Office of U.S. Attorney representing the United States government. Now, let me tell you, you look at it, even from a layman's point of view, look at it this way. If your case is assigned to an officer, let's say there's an officer in Dallas who is handling your case, and your case has been unreasonably delayed. Maybe the I-130 petition has been pending for 3 years, no action. And then you decide to file Mandamos action. And that Mandamos action is served on the Attorney General in Washington, D.C. Do you think the Attorney General is going to contact the officer? No. The Attorney General is probably going to call the Secretary of Homeland Security, who will probably call the district director, who will probably call the district officer. What is going on with this case? So by the time they get to the officer who is handling the case, if that officer is actually not doing his or her job, then it becomes problematic. So even if they have other things they are doing, they are going to abandon it and quickly bring up your file and adjudicate it. Again, one thing I don't want you to misunderstand, Mandamos does not mean your case will be approved. Mandamos does not mean that your case will be denied. Mandamos simply means calling or forcing immigration to do their job. So if your case is approvable, they will approve it. If your case is not approvable, Mandamos is not going to change that. But they have to take a decision. That is what Mandamos is all about. They cannot just keep quiet. They cannot just sit on the case. They have to adjudicate it. The next question. Is a response guaranteed when an ombudsman request is filed? No, nothing is guaranteed. All those administrative steps, nothing is guaranteed. Nothing is guaranteed. And sometimes even when you get a response, it may be the same generic response that we always get. So there's nothing guaranteed in terms of administrative processing. You do a service request, they come back with generic response. Oh, we apologize for the delay. This case has taken long because the security has not cleared, or background check has not cleared, or all those generic nonsense. Those are the kind of things that they send most of the time. So sometimes it is the same generic response that the ombudsman gets. Sometimes it is the same generic response that the congressman's office get or senator's office. It's the same generic response that the lawyer's office get. So sometimes I've seen several cases, maybe over 20 cases where immigration send us generic response and then we file Mandamos. Then suddenly those security delay, they disappeared. What changed? Because somebody took the right step. That's the only thing that changed. The next question. I'm the beneficiary to an employment-based petition. Does my employer need to submit any request, service request, ombudsman, or even Mandamos, or do I submit it on my own? Well, if you are the beneficiary of an employment-based petition, there are things you have to look at before you even before you consider Mandamos. Number one, the petition that you file, is visa available? That is why I was saying that it is not everybody that is eligible to file Mandamos, because even if your case is pending for 5 years, if what is delaying it is because visa is not current, then there's nothing immigration can do about it. That is outside their authority. The only person that can change that is the US Congress. So that's not something you can file Mandamos for. So if your case is pending, the first thing you need to look at, why is it pending? Is it being delayed because visa is not available? Because if visa is not available, USCIS does not have the authority to approve the green card. So if your employer filed I-140 on your behalf and that I-140 was approved, and on the basis of the approval, you file the I-485, application for permanent resident, and then the visa is not current for your category, no matter how long the case is pending, you cannot file Mandamos, because immigration cannot violate the law because your case is being delayed. No, that is something that they don't have control over. The same way we wait for visa bulletin every month, that is the same way immigration themselves wait for it. Congress empowered the Department of State to release the visa bulletin on monthly basis. So if visa is not current, that is it. That kind of delay cannot be correct, cannot be cured by Mandamos. The next question. I think I answered it. How long does it take to get action after filing a Mandamos case with federal court? Maximum, I tell you, maximum, not the minimum, maximum 60 days. Maximum 60 days from the date of service, not from the date of filing. Because, like I said, once a Mandamos action is filed, you have to serve the Attorney General of the United States. and you also have to serve the U.S. Attorney's Office. The U.S. Attorney representing the United States in this mandatory. Otherwise, the court will give a default judgment against them. And of course, another thing that I always do to ensure that they don't ignore the Mandamos action, even though, like I said, America is a country of law, they cannot ignore it. But additional thing to put them on their toes is that I ask for attorney's fees. I ask for fees. So even if at the end of the day the case is settled, because from personal experience, I will tell you 98% of all Mandamos cases that I've ever filed in this country are settled out of court. Because like I said, usually once you take this step, immigration will be on their toes. They will quickly adjudicate the petition, and then their lawyer will call me and start saying that, oh, okay, now that this petition is approved, can we please settle this case out of court? Can we withdraw the case? So 98% of the time, that is what happens. How long does it take to get action? Oh, I just answered that. What are the minimum requirements to file Mandamos? Well, it is better to seek advice from an experienced immigration attorney. But to answer this question, the first thing you need to determine is what type of application is it? If it is a family-based application, especially immediate family, like I-130 petition, there is no issue of visa bulletin. There is no issue of visa being current or visa not being current, because for immediate families of a United States citizen, there are no numerical limits. So that problem does not exist. So that is the first thing you need to check. The second thing you need to check, if it is a case that falls under visa bulletin, you have to check, is visa current for that particular case? Because if visa is not current, USCIS does not have authority to adjudicate, because they cannot approve something illegally. If there is no authority to issue green card, they cannot issue. Every single application has a processing time. All you need to do, go to USCIS website, put in the click the one that says to check the status of your case, and then go to the one that says processing time check, and then put the form number there, choose the office where your application is pending, and file it. Are you still within the processing time, or are you outside the processing time? Usually, if you are still within processing time, USCIS system will not even allow you to submit service request. So if you have been in a position where you have to submit service request, that is already an indication that they have exceeded the processing time, because they will not allow you to submit service request if your case is still within processing time. So that is the second thing. Then the third thing you need to determine is how reasonable is the delay. If the processing time says 12 months, you can't file Mandamos on the 13th month. I mean, that delay is extremely reasonable. So you give them space. So if the processing time says 12 months and your case has been pending for 24 months, that is more than reasonable. So if you meet all of these requirements, then you are good to go. And like I always say, he who lives in a glass house does not throw stone. Mandamos is not going to make them approve your petition. Mandamos is not going to make them deny your petition. So if your case is not approvable, going to file Mandamos is not going to change it. We need to be clear about that. If your case is approvable, going to file Mandamos will not make them deny it. So it is still going to be adjudicated on its merit. So Mandamos is not going to have any effect on whether the case is approved or denied. No, that is not the purpose of Mandamos. Mandamos simply means do your job. It simply means the court is telling USCIS to do their job. Simple. The next question. What is the chance that repetitive service requests will expedite the adjudication of the application? Well, that is something that we cannot determine. Sometimes when you do service requests, sometimes they act on it. Sometimes they just come back with a generic response. The problem is that you or even me as a lawyer or your lawyer is not going to know the exact reason that is causing delay. You are not going to know. In fact, let me give you one example, one case that I did a Mandamos for. Do I call this recently? I think it's probably about 2 or 3 years now. So I don't know whether I should call that recently. This client, the family applied for green card as investors. The petition was approved and the green card was approved. So we were expecting the green card to be mailed to us. They mailed the green card for the principal beneficiary and the children. They did not mail the green card for the spouse of the beneficiary. But we have the approval letter, we have everything. So we kept calling. We have not received this green card. They will tell us, oh, sorry, we will mail it out. So meanwhile, the family wanted to travel out of the United States. So we decided that the derivative spouse should go to immigration office to get her passport stamped. So the passport was stamped and then they travel out of the country. But guess what? When they were coming back, they provided everything that they had, including the approval letter, the stamp, but for some reason, the airline decided to call. I don't know who they call at immigration office, but they claim they called immigration office and they were unable to verify that the person was a permanent resident. So they almost got stuck outside the US. But eventually, we tried so many things. We called immigration, we filed different things. Eventually, they were able to come back to the US. We kept requesting that the green card be mailed out. At a point, I decided to file what is called I-90. That is to replace a lost green card. Okay, you claim you mailed this green card. We didn't get it. Okay, replace it for us. And you know what? They would deny that application that, oh, we cannot replace it because the one we mailed out was never returned to us. We were on this issue of getting this green card for 2 years. Everything I could file, I filed. They were just going in and out, inconsistent responses. We will file this, the response will be different. When we file something else, they will give a different excuse. At the end of the day, Mandamos can do. Those are the things. The next question. My petition, I-130, has been pending for over 4 years. Every time I submit a service request, I do not get a response. What is better at this point? File an ombudsman request or Mandamos? Like I said, every case is different. I don't know the details about this I-130. I will suggest that whoever sent this question, consult with your lawyer. Make sure that your I-130 is approvable. If your I-130 is approvable, you don't even need to go to any ombudsman at this stage. If your case has been pending for 4 years, that is completely unreasonable. Go ahead and file the Mandamos, and I guarantee you that 60 days from now, you will get your response. But if your I-130 is not approvable, if your house is not in order, do not do it. Because Mandamos is not going to make them approve anything that is not approvable. And Mandamos is not going to make them deny anything that is approvable. Mandamos simply means do your job. The next question. What is the filing fee to filing Mandamos? Well, that's not something I'm going to discuss online. Every lawyer has their own way of doing things, and of course, every case is different. We don't discuss fees on this type of situation. This is not immigration. This is not immigration filing. We are talking about court case here, so that one is not something we are going to be discussing during this podcast. How much does it cost to file ombudsman request? That one is free. Ombudsman is free. You don't pay for it. It is similar to service request. They are just some kind of third party who are trying to assist people. It's like when you deal with IRS, there's something called taxpayer advocate. So ombudsman is like advocate for applicant, for petitioner. So they are just doing pro bono service. And that's why sometimes the response is not really something that can be guaranteed, because they just contact immigration the same way the petitioner himself or herself can contact immigration. The same way we can file a service request is similar thing that ombudsman will do. So you don't pay for it. It's free of charge. The next question. From what you are saying, filing Mandamos means suing USCIS. Are there any repercussion? No. 100% no repercussion. And like I said, I've been doing this for 20 years. I've been suing immigration. In fact, I can tell you, I file an average of 5 to 10 Mandamos cases annually in the last 20 years. I file an average of 5 to 10 Mandamos cases in the last 20 years. So, and I'm yet to see one single case where there was any negative repercussion. No, this is a country of law. This is a country of law. Let me tell you, I was not born in this country. As you can see from my accent, I'm a foreigner. And I tell you, the law is the law. The same law that applied to me is the same law that applied to people who were born here. So, the law is the law. There is nothing. There is no repercussion for enforcing your right, because you paid for this service and you are entitled to the service. So there is no repercussion. But if the case is not approvable, it is not approvable. If the case is approvable, Mandamos is not going to change it. There's nothing. There's nothing. The next question. There's a lot of noise from there. The next question. I read online that I can request something called InfoPass appointment with USCIS. Will this appointment get them to make a decision on my case? I don't think so. Usually, InfoPass appointment is for you to go and do something at immigration office. Maybe you need to go there to go and get your passport stamped. Maybe you need to go there to go and obtain emergency travel document. Maybe you need to go there for, so it's not for adjudication. Usually it's not going, InfoPass appointment is not for adjudication purpose, because the people that will attend to you at InfoPass are not the same people that are adjudicating your case. So it may not, that does not mean that it may not have impact. For example, if your case is pending at the local office and then you go and attend InfoPass appointment, you can bring it up with the officer that what exactly is causing delay in this case. And because this is a man-to-man opportunity, or a woman-to-woman, or a man-to-woman, the adjudicating officer that, okay, this case has been pending for so what is going on? So it may have that kind of impact, but generally, purpose of InfoPass is to go and do specific thing at immigration office. Usually, maybe to go and stamp your passport, or maybe to go and obtain emergency travel permit. The next question. I have an asylum claim that has been taking many, many years. There is no posted processing time for asylum. How can I decide when to file Mandamos if necessary? Well, this is a very, very, very good question, because I don't believe that asylum is a good case for Mandamos. I don't believe so, because number one, you don't pay for asylum. Remember when I was explaining this thing, you can only force somebody to do their job when you pay for it. So if immigration were to be a private citizen or a private business, and you pay for their service and they refuse to do the service, what will you do? Will you fold your arms? No. You paid for the service and they have to do their job. But asylum is an exception. You don't pay for asylum. Asylum does not have filing fee. Asylum is more like something I don't want to use the word discretionary, but it is a privilege. It's not a right, it's a privilege. And they don't charge for it. So you can't file Mandamos because you didn't pay for the service in the first place. So I will consider asylum case an exception to Mandamos action. In some cases, you may still have basis to file Mandamos action, even based on asylum situation. For example, I think it was in 2021, American Immigration Lawyers Association, they filed a lawsuit against immigration regarding delay in processing employment authorization for asylum applicants. That is a little different because, one, you pay for employment authorization. Asylum application is free, but employment application based on asylum is not free. You pay for it, $410. It's not free. So anything you pay for, you may have a right to complain if there is a delay. But anything you don't pay for, you can't complain. You are at their mercy. They will attend to you when they are ready, because it's a service they are giving to you without you paying for it. The next question. Which one did I answer just now? I read online that I can request InfoPass. No, not that one. I have asylum claim that, okay, not, I think that, okay. The next one, I apply for premium processing in my case. I received a status message that stated 15-day premium processing clock was stopped for my case. What does that mean? Well, that means that either immigration has issued a request for evidence for your case, either they have issued notice of intent to deny. It means that there is something that causes delay, that put a stop to the processing of your case. The fact that you apply for premium processing does not mean that your case is approvable. If there are documentary evidence missing and immigration decide to issue a request for evidence, usually they cannot give you 15 days to respond to a request for evidence. So they may give you 30 days, they may give you 87 days, they may give you 3 months to respond to it. So if you don't respond within those time, you can't blame them for not adjudicating your case within 15 days. So as soon as they need additional evidence or additional document relating to your case, they put a stop to it. So whenever you respond to it, then they start the 15 days all over again, because you are going to put them under undue pressure, accusing them of breaching the contract to adjudicate your case within 15 days, whereas you are the one that didn't provide all the evidence that is required. So that's why they usually put a stop. So it seems if you receive such a notice, it means that they have issued a request for evidence in your case. The next question. Another question about premium processing. Do federal or state holding holidays make disrupt my premium processing time? No, it does not. For premium processing, it is calendar days. They don't exclude holidays. They don't exclude weekend. It is calendar days. However, there is a request recently. I don't know if immigration has actually started implementing it, but there's a proposition recently by immigration that they want to extend the processing time, premium processing time, from 15 days to 30 days. But I'm not 100% sure when that decision is going to take effect. But if you receive 15 days notice, then the 15 days does not exclude weekend or public holiday. It is calendar days. Question. I filed an appeal and the reason I will explain. There are 50 states in the United States. Immigration offices, USCIS offices, they are present in every single state, and they are present in most cities. There are immigration courts in every state of the Federation, and there are immigration courts in most cities. Appeal from all the immigration courts across the United States and appeal relating to certain petitions from USCIS all across the United States, all of them go to the BIA, and there is only one BIA office. There are not 2, there are not 3, there are not 4. Only one BIA office. So, I mean, it's not something that you just have to wait until they get to your case. So that is it. Probably maybe if Congress decide to create additional BIA offices, maybe that can resolve the problem. But what you can do, you can call them. You can keep calling them. Sometimes you may think that your case is pending and your case may not be pending. So, because even as lawyers, we have seen that happen. You may think these things are pending and they may not be pending. So the next question. When a case status shows approved under USCIS and say it's now with the MVC, but we have been waiting for a while but no major update from the NVC, The claim is NVC is waiting for the home embassy of the beneficiaries for an interview date. The embassy is claiming they have no file or notification from NVC. What can one do? Well, this is a little different from Mandamos situation. However, I want to explain this. At least, like I said before, I have been filing Mandamos action against USCIS for about 20 years now. And there have been situations where I filed Mandamos action against the Department of State. NVC is part of the Department of State, is under the Department of State. US embassies across the world, they are all under the Department of State. There have been at least, if I recollect correctly, at least there have been about maybe 4 or 5 cases where I had to file Mandamos against the Department of State. However, the facts of those cases are different from this. If I recollect correctly, the most recent one was actually during COVID. This person, the client, a US citizen, petitioned for her husband. Her husband the process was completed, interview was granted at the US embassy. The husband attended the interview, and then the embassy promised that they will get back to him. We waited and waited and waited. 6 months, no response. We will call, they will say, oh, send us your passport. They will send the passport. Oh, when we make inquiry, oh, we didn't get the passport. Meanwhile, there are proof of USPS delivery of the passport. They kept on giving all kinds of excuses. I mean, it got to a point that the whole thing was very, very frustrating. And I advised the client that I think at this stage we needed to file Mandamos. And of course, filing a Mandamos against the Department of State and filing a Mandamos against USCIS, they are not different, because whenever you sue an agency of the United States, you still have to serve the Attorney General of the United States, and you have to serve the U.S. Attorney in the local office where that Mandamos is filed. So it is still the same thing. It is still the Attorney General that will defend the case. So definitely it is still the Attorney General's office that will contact the embassy to find out what is causing the delay. But in this case, the reason why I said that the situation here is a little different. Since 2016, there were 4 different things that created backlog for cases that went through or that are going through the National Visa Center. I can see the name of the person who sent this question, but I'm not going to mention the name. But I do know that this person who sent this question is a Nigerian. So that is why I'm going to address the Nigerian situation. There are 4 things that created a major backlog in the Nigerian situation. Number 1, we will recollect that when Donald Trump was American president, one of the first things that he did was to ban immigrant petition from Nigeria. Not only Nigeria, Nigeria was just one of the countries at the time. So he banned the processing of immigrant petition from Nigeria. So what that means was that every single case at that time that has been approved, that were ready for interview, every one of them were put on hold. This executive order at the time, before the court overturned it, the executive order lasted for several months. Even if not to up to a year, I can't remember precisely how long. Because I remember they had to go through the court. Even when the court ruled against him, they filed an appeal. At the end of the day, they created a major backlog for cases coming from Nigeria. That is one of the several reasons that created problem. Number two, Donald Trump's enforcement priority. Even after the court lifted the ban on immigrant processing from Nigeria, because of the increased enforcement rate during his time, the number of applications and petitions increased tremendously. That added to already backlog situation. That was the second thing. The third problem came with COVID. COVID struck again, and at the end of the day, every governmental activities were placed on hold, including inside the US and outside the US. Everything was placed on hold. I mean, for several months, nobody could, in fact, they were not even, embassies were not open. Nobody could get any appointment, nothing. It was chaotic. Even they canceled Dropbox, even for people who just want to merely renew their visas. Everything was chaotic. That was the third problem, creating additional backlog. Then 4, and the last one. Now, because backlogs have been created, the Nigerian factor kicked in, connection. And one thing we need to understand is that there are diplomatic challenges for the American embassy in Nigeria. If the Nigerian government or ministers or powerful people in the government, if they make a request to the US embassy asking for appointment, the embassy does not have a choice. They will give them priority over regular applications, regular petitions. So at the end of the day, they keep adding to the backlog. The issue is, does that mean you cannot file Mandamos? No, it doesn't mean that. You can, but you have to leave enough room. So that is my answer. You can still, it doesn't stop you from filing Mandamos. You can still do it. But of course, you must have enough room. That, look, we have been waiting. I mean, we in this office, we have cases that have been documentarily qualified since 2021. This is 2023. Cases that have been documentarily qualified. So if any of those cases is family-based, immediate family, if I am the petitioner and I can afford it, I will go for Mandamos. So I believe that was the last question. Do I still have any question I'm expecting? Okay. It's also, I think our time is up, and I believe I've answered the last question. That was the last question. Okay, so in the absence of any unanswered questions, so it means that we'll be putting a temporary hold on our podcast for today. We hope to resume again next week. Please remember to invite your family, friends, colleagues at work. Remember to invite them to be a part of this podcast. You will agree with me that we provide useful information every week, and we do this free of charge. We are not expecting anything in return. So the only thing you can do to show appreciation for what we are doing is to ensure that other people benefit from it. So let other people know. Invite your friends, invite your family. Go back to if you miss it, go back to our video on our YouTube channel or Facebook page. Listen to it. Also subscribe to our channel so that whenever we go live, you'll be notified and you will not miss anything. So, see you again next